The same document shows that it's signed from Fifth Third's headquarters in Cincinnati, Ohio, by one of the officers of the bank, who happens to be a public funds officer. So that proved to me that Fifth Third Bank is actually acting as an agent for the government. And that's something that a lot of people don't really quite know about. Now, it said in the publications that they loan checkbook deposits, is what they said. Now, some of these court cases say a national bank cannot lend its credit or become the guarantor of the obligation of another unless it owns or has an interest in the obligation guaranteed, especially where it receives no benefit thereof. Another one, a national bank has no power to guarantee the performance of a contract for the sole benefit of another. Well, these two court cases, to me, contradict themselves. And the reason for it, to me, is it says it cannot lend its credit or become the guarantor of an obligation of another unless it owns or has an interest. Well, if you hand your money to a bank, it has an interest. It has a fiduciary responsibility, fiduciary duty to hold that money for you. So they do have some interest there. So even if they do have an interest, it says further down here in this other court case, a national bank has no power to guarantee the performance of a contract made for the sole benefit of another. Well, even though they have the fiduciary duty to hold that document, they do not have the power to guarantee performance made upon that holding. It says down here, national banks have no power to negotiate loans for others. And that's actually what's going on. National bank cannot act as a broker in lending depositors' money to third persons. A national bank is not authorized to act as a broker in loaning the money of others. So it's very clear that they're saying one thing here, that they're loaning depositors money, but the courts are saying that they can't do that. So there's an issue here, as far as I'm concerned. National bank receiving the proceeds of a customer's note and mortgage with authority to pay out the same upon the first mortgage lien of real estate is acting in intra vires and liable for breach of duty. Wow. A national bank receiving the proceeds of a customer's note and mortgage. Well, that tells me that proceeds were granted to the bank as a result of the notes and mortgage. That's kind of interesting. I didn't realize that notes and mortgages were purchased and sold. I was induced into believing that if I ever went, when I did go to GMAC, that GMAC was going to give me their money, their own capital, their own assets, and I would have to pay them back. And they were drafting up this document to hold on to. In the event I didn't pay back, they could use that court to enforce the two promises back and forth. Well, this right here just totally contradicts the entire thing because it says it's acting in ultra vires. How is that possible? They say one thing and do another. Interesting. National Bank is not authorized under national banking laws to lend deposited money on depositors' behalf. The reason I'm bringing this up is because so many times people and bankers will come up to me and say, well, we loaned out depositors' money. Well, that brings up a question to me. If I go down to your bank and I put $1,000 into it, into a checking account, and what you're saying is that you're loaning out depositors' money, what you're saying is if you loan my money out, I can't come and get my money out because you've loaned it to someone else. Brings up a very, very layman, simple question. How can money be in two spots at the same time? It can't. Except, of course, under their rules. Well, the court here says that they can't even do it. Even if layman's common knowledge says that money can't be in two spots, the court is saying that the bank is not authorized to do it. Under the section, a national bank had no authority to enter into a contract for loaning money of depositor kept in deposit account, though its cashier authorized by the deposit to withdraw thereon to make loans. A bank has no right to loan money of other persons. Interesting. So I'm hoping to show you that they can't use depositors' money like they claim. And the reason that I like to go through this is if they're saying they're doing something or that the law allowed them to, the laws are saying they can do certain things, and what I'm trying to do is I'm trying to do the process of elimination. And if you do the process of elimination, you're going to come out to what really truly happened. Okay, you said you loaned depositors money. No, that can't happen, so that's out of the equation now. So where did the money come from? Where did the money come from? The Federal Reserve publication says it's from their deposits, checkbook deposits. Well, the court disagrees with that in history. So what exactly is it? Brings us to another Federal Reserve publication called Modern Money Mechanics. Now, this publication, for all practical purposes, has disappeared. Matter of fact, you may want to call up the Chicago Federal Reserve Bank and ask them for this, because you can see, here's an original one. It is real, it's new, but copies of this workbook are available from the Federal Reserve Bank of Chicago, P.O. Box 834, 312-322-5111. However, they no longer offer it. Probably because of some of the statements made on page number 3. Page number 3 says, everyone soon found that this was a lot easier, simple, to use the deposit receipts directly as a means of payment. Read that again. Everyone soon found that it was a lot easier simply to use the deposit receipts directly as a means of payment. Swipe a credit card, there's a receipt. They use that receipt as a payment. I thought this was a loan of money. Well, that brings me to the Federal Reserve Board of Governors Purpose and Function book. Because now I have to understand what do they mean by money, because they're saying that now is actually used as payment. Did they pay me in money? Did they pay me in checkbook receipts? Did they use depositors' money? There's so many different theories out there. I want to use their publications and their own rules and guidelines. In the very back of this, it gives definitions. And what was amazing to me is when I got to the definition of money, it says anything that serves as a generally accepted medium of exchange, a standard of value, and a means of saving or storing purchasing power. Well, if money is the Federal Reserve notes that they claim it is, you know, these little bills, why don't they just say that? They're saying in there that it's a value of exchange. Well, if this piece of paper is my promise, then it has value because it is a future contract. It's a promise. So the note itself at this point would seem as though that is the debt and the asset. Let's continue on here. These receipts, which became known as notes, like a promissory note, were accepted as money, since whoever held them could go to the banker and exchange them for metallic money. Then bankers discovered that they could make loans merely by giving their promises to pay, or bank notes, to borrowers. In this way, banks began to create money. More notes could be issued than gold coin on hand, because only a portion of the notes outstanding would be presented for payment. Enough metallic money had been kept on hand, of course, to redeem whatever volume of the notes was presented for payments. Transaction deposits are the modern counterpart of banknotes. It was a small step from the printing notes to making book entries crediting deposits of borrowers, which the borrowers in turn could spend by writing checks, thereby printing their own money. So another publication that kind of leads you off into a whole different realm now. Now it's not necessarily depositors' cash. It's not the cash that we thought. Maybe they didn't loan us cash. Maybe they just loaned us a piece of paper, which was a promise. It brings up more confusion every time you go down these rabbit holes. So what I've done is I've went through and found out, specifically talking about mortgages now, I needed to go out and find what exactly is a mortgage? What exactly is a note? I just don't have an understanding of that. So I was browsing through Westlaw, which is the annotated version of the United States Code. And what I had found is I found a court case. And this court case is called Wheeler versus Sohmer, S-O-H-M-E-R, Comptroller of the State of New York. I would think that the comptroller of the state of New York and the judiciary in New York would have a very, very good understanding of what money really is and what a note is. And here in one of their footnotes, number 10, it says promissory notes are only evidences of debt and not debts themselves. Well, that brings up a whole new question now. Where's the debt? The publications are making you believe that the note is what's used as payment. And they're also enforcing these things in court, calling these things obligations. Well, an obligation is an asset according to their own publication. Their publications tell you that every obligation is someone else's asset. Well, now the court here and the comptroller of the state of New York are both saying that promissory notes are not debts. Well, if this is not a debt, then it can't be an asset either. So where's the debt? Maybe it's in the mortgage. Maybe it's in the mortgage. I want to bring up a couple other things inside this one court case here. It clearly establishes a note. We know it's our only evidences of debt. Down here it says the notes are but the evidence of debt. And then down here it says the debt due, of which the notes are evidence, is property vested in the owner. That's kind of interesting, except perhaps where he has conferred authority upon someone else as his agent to loan, manage, receive, and collect the same for him. In such case, it might be reason to be held that the situs of the property was the domicile of the agent. In other words, the situs is the legal bond, the legal glue between you and the bank. That's the situs, your commercial legal contracting upon each other. So we now know that notes are not debt. Well, if it can't be a debt, it can't be an asset. We know now that they can't use depositors' money. So there, you can see the conflicts going on here. So now we've got the note out of the way and we've got depositors' money out of the way. They can't use either one of them. So where did this money come from that they claim we owe them? That's the only thing I really want to try to decipher today is where did the money come from and how did the bank have a right to say that there's an obligation? That brings us to the mortgage. Now the mortgage I found in specifically the annotated version of the United States Code at Westlaw, I found 12 United States Code 3754. 12 USC 3754 goes into and talks about the authority to foreclose on mortgages. I'll get to what that talks about later because I want to just talk about what a mortgage is right now, because 3754 of 12 USC plays in a very intricate part in what I believe is the greatest, again, gross misrepresentation on the people. If you go into corpus juris secundum, which corpus juris secundum is one of the legal historic documents for all cases, all citations, and all law in the country. 59 corpus juris secundum mortgages. In section 2, it covers some definitions. And in here, what I'm looking for is a definition of mortgage. The literal meaning of the word mortgage is a dead pledge. The term mortgage may be employed as meaning the debt secured by the mortgage. But in its true sense, an ordinary mortgage is not a debt, as the debt is the principal obligation and the mortgage is generally regarded as merely an incident or an accessory to the debt. So again, the mortgage is an accessory to a debt. Again, we haven't found out where the debt is. But more times than not, I hear of people going into court and they're being foreclosed on, or they're behind on their payments, or whatever the case is. There's an issue between the bank who holds the quote mortgage and their alleged customer, and they put a mortgage up there and a judge looks at it and says, yep, you owe it, that's a debt, let's go. Well, this proves that it's not a debt. It proves that it's an accessory to a debt, which again doesn't define where the debt really truly is. But to me, being an old car Nazi that I was from the auto industry, I understand that an accessory to a car is going to be an aftermarket stereo. It's going to be hubcaps or the nice chrome wheels that go backwards as you're going forward, you know. And if memory serves me right, if I put those on one of my automobiles or cars, some accessory, a radio, And next thing you know, the car is gone, but the radio is sitting there. I don't believe I have proper standing to take that accessory, i.e. the radio, into court and claim ownership over the car. There needs to be a little bit more investigation. I can't take a hubcap into court and say, I own that car, here's my hubcap. That's not going to fly. Yet the court and the bank are allowing that to happen every day with these mortgages. I just don't understand that. The courts have very clearly defined a mortgage as an accessory to a debt, and these bankers and lawyers are walking into court using an accessory and getting away with, quote, ownership just because of bringing a hubcap into court. Yet if we do that, we're laughed at. It doesn't make sense. Now, to drive this home, all of these court cases right here amplify that. It's not just one court case. You've got several different court cases stemming on that same regard. Caddy versus Cortite, New York, Testy versus Collins, Baker versus Citizen State Bank of Lewis Park, U.S. versus Stanley. Here's Wyoming. Appeal was dismissed. They tried to appeal it and it was dismissed. No, it's already done. And the reason that it was already done is because the statute, the intent of Congress, and then there was a confirming court case. And if somebody would bring a statute and the confirming court case into a court, it really doesn't matter what the judge says. If someone just brings the statute and the court case holding, which confirms that statute into court, it really is irrelevant what the judge says, because the Congress and the intent of Congress and the judiciary has already confirmed it, and there is no matter before the court now. It's already been clearly established and well written in the history of the books. Here's the statute, which is the intent of Congress, and here's the judicial confirmation of it. And the reason I say that there's no matter here, because if the judge wants to rewrite the law and say that's not right, the separation of powers doctrine jumps in. He needs to go to the legislature and have them rewrite the intent of Congress, because he can't. That's the separation of powers doctrine. I hope you're seeing where I'm going with this. It just doesn't work with what they're saying, that they're claiming that they have a right, but I don't know where that right came from. Now, what I'd like to do is I'd like to go right straight to the statute here for a moment and read to you straight from the statute, or show you straight from the statute what exactly it is that the intent of Congress reads regarding banks and banking. And it's going to take me just a sec to get here. 13 Stat 99, which is also known as Title 62 of the Revised Statute. And for all practical purposes, when you're trying to find the statutes at large, you're going to have a very hard time finding it, because they make it so convenient for you to find. You could go on Cornell Law and go over to the right, and it's in the notes section, and then go into the source, and it'll tell you the statute. Like here, Title 12 United States Code has 33, according to United States Code, Cornell Law, there's 33 different sections in Title 12 that refer back to Title 62 of the Revised Statute, which is 13 Stat 99. And when I say 13 Stat 99, what that means is it's the 13th Congress on the 99th page. Okay, so you have to go to the 13th Congress, go to page 99, and voila, you're going to find the several different pages regarding banks and banking. Okay, there's 20 pages. That's not very much. 20 pages tells the intent of Congress on banks and banking. Yet you go into Title 12 of the United States Code, and you have literally hundreds of thousands of sections of codification from the Law Research Group. The Law Research Group takes these 20 pages and rewrites them into the United States Code. United States Code turns out to be 4 books or whatever it is, yet you've got 20 pages, which is the intent of Congress. Doesn't make sense. It looks like maybe there's a possible intent to confuse or distract. So when I first get into this on page number 4 of 20, you're going to find section 9. Again, this is back in 1864 is when they wrote this, and this is page number 102. 13 stat 102 is what this specific page will be talked about. Now right here, section 9 talks about every association, and you have to understand in the statute they're talking about associations being banking associations. Whether you're a state bank or member bank, most all of those are going to be part of what's known as a holding company. And a holding company is just going to be a bigger bank that holds a whole bunch of smaller banks in it, and they all form what's known as an association of some kind. So this section 9, a codifier is going to take section 9 and put it into Title 12. But if they change so much as a period, a comma, a quotation, if they add any of their own words or take any of the other words out, then it cannot be positive law. It can only be prima facie at first glance. But section 9 is what I really wanted to talk about here, because this is where I actually started getting some help from these people. At first, when I started asking questions, the consumer help hotline, I'm sorry, but them people had to have worked at Burger King or something, or they at least acted as though they did, because I don't know what you're talking about. Those words don't make any sense. That doesn't make sense. You're crazy. So I started to get a little bit more formal on my letters, and then I started getting responses back from their legal division, who basically told me that I'm radical, I'm crazy, I don't know what I'm talking about, all your claims are frivolous, you don't know anything, and so on and so forth. But all I wanted was an answer to my question. I don't care if I'm frivolous or not. Just is this the law, yes or no? Well, it's frivolous. Well, I'm sorry, but that's non-responsive. I just asked for a simple yes or no. Is that hard to do? Especially if you're saying you're here to help me understand, and that we have this good binding relationship. What's so hard about just saying yes or no? And I found out why. And I also found out how to get them direct yes or no's. In section 9 here, it says, "And it be further enacted that the affairs of every association shall be managed by not less than 5 directors, one of whom shall be the president." That will be codified in Title 12. All of these sections are in Title 12. Any other sections are just prima facie evidence. So you'll see that there's several sections, about 64 sections, that are positive law, and all the rest of them are just codifications of what the assumptions, theories, and beliefs and opinions of the legal team that drafted these. It goes on further to say that every director shall during his whole term of service be a citizen of the United States. Each director whom appointed or elected shall take an oath that he will, so far as the duty devolves on him, diligently and honestly administer the affairs of such association, and will not knowingly violate or willingly permit to be violated any of the provisions of this act. Well, that means that he is going to work in a upstanding, honest, forthright manner, but it also very clearly says in there that he will not knowingly permit or willingly permit to be violated. Well, he's in charge of all the employees, so if one of the employees is acting in bad faith, you need to bring that up to the director, because he holds an oath to office to make sure that nothing administered under him is done wrong as well. And that's very important, because if someone has questions with their, quote, bank that they have a good relationship with, if they won't give you answers, I would most definitely try to get with one of the directors, who also, one shall be the president. So the president of the bank is actually a director of that bank too. So if people are having a hard time trying to get a hold of any answers, direct yes or no's, it might be a very good start for you to start right there. And then it's either on page 10 or 11. It's page 11. I'll go to the next one here. And this one is going to be a little bit more provocative as to what banks can and cannot do, which is where I start getting into more of this process of elimination. Okay? I found in 12 U.S.C. Chapter 2, Subchapter 4, Section 83, it stated that no national bank shall make any loan or discount using the shares of its own capital stock. Okay? Well, at first, someone's going to say, well, gosh, they can't use their stock. But you really have to understand what capital stock is. And briefly, capital stock is where the directors, there has to be 5 or more according to Section 9, 5 or more directors put their money into a pool. And that's what causes or creates the stock of the company. Okay? That money cannot be touched or loaned out for any reason whatsoever, because if it was pulled out, the stock options would just deplete instantly. I believe, I don't know this for sure, but I believe they can add to it, but they cannot loan it out or they cannot pledge it anywhere else because it's already been pledged here as capital stock. And it makes total sense when you look at it. But just to show the people that although this was written in 1862, 1863, it is not obsolete because I just connected it to 12 U.S.C. Chapter 2, Subchapter 4, Section 83, currently on the books. Right here, Section 35 says, and be it further enacted that no association shall make any loan or discount on the security of the shares of its own capital stock. However, look how large this paragraph is. The codifiers put a period here and left out, nor be the purchaser or holder of any such shares, unless such securities purchased shall be necessary to prevent loan upon a debt previously contracted in good faith, and the stock so purchased or acquired shall, it gives other descriptions. Why is that left out? Why not just post this on the website? Why not? Why not just say, okay, here's the intent of... You know how many trillions and trillions and trillions of dollars this country could save and the government could save if they just took the codifiers and threw them out and put the intent of Congress up? 20 pages. We would understand banking. We would know what we could and could not do. Why pay all these billions and trillions of dollars to codifiers when it's very simple right here? Secondly, why hide this from the general public with the annotated court cases which give relevance to this? Those 2 sections are hidden from the general population. Yet the code, which is totally perverted in most cases, I'm not going to say all the time, in most cases it's totally perverted, that's accessible to everybody. As far as I'm concerned, again, in my world, that's gross misrepresentation, but not coming from the bank. That comes from the actual codifiers and the lawmakers itself of America. I want to go down to Section 37, which is just 2 down from it. Because now we know that the bank cannot use its own capital stock. It can't use the bank's depositors' money. And it cannot lend credit. So any 3 of those answers, they can't do that. They can't lend credit. They can't use the depositor's money. And I imagine they probably could use the depositor's money as long as the depositor knew. I mean, if I knew that they were going to possibly loan this money out to somebody else, you know, I could probably negotiate a deal with the bank. Say, you know what, why don't you just give me 5 or 6% on that money and I'll do that. However, that's not commonly known to people. When someone goes to set up a savings account or checking account, they're not told that. Most people want to say, I just want a non-interest bearing checking account. Okay? Well, there's no negotiation that I'm aware of that the bank says, well, we might be loaning your money out. I was never told that. And in contract law, it's extremely relevant that both parties know and understand and agree to each and every element of that contract. Otherwise, there is no contract. It's not a voidable contract. It's just void. A void contract means it never existed. A voidable contract is one that does exist, but is voidable due to bad faith or breach of duty or so on and so forth. 37 section says, and be it further enacted that no association shall either directly or indirectly pledge or hypothecate any of its notes of circulation for the purposes of procuring money to be paid on its capital stock or to be used in its banking operations or otherwise. Well, that clearly establishes that any notes of the bank cannot be pledged or hypothecated directly or indirectly in any fashion. Because that word or otherwise clearly tells me they can't use them. Which goes back to the notes. Well, what I see there is that the bank can't use its note. Is this the bank's note? That brings us up to who really issued this then? Who issued this? Did the bank really issue this note? If they did, they just violated federal law. But when you flip a note over, you're going to see it only gives you one option for signature. It doesn't even have a spot for the bank to sign. There's only one signature, and it happens to be you. So that note is yours. However, that note cannot be a debt according to the judges in the judicial system. And if it's not a debt, according to the Federal Reserve publications, it can't be an asset. So this is the hubcap to a car. Just like the mortgage, these two items are just hubcaps to a car in law. According to the courts and according to the laws that are written, these are not debts. If they're not debts, they're not assets. Where did the asset come from? As far as I'm concerned, it's all one great big smoke-filled mirror of a belief system. You believe that there was a debt. You believe that this is money. You believe that this has actually got value to it. It's a belief system. If we stop believing in this, what's left? I mean, if this really truly had value, here's a nice little test for you. If this really truly had value to it, could you go to the Federal Reserve and get bullion for it like we used to? If they don't give it to you, then this isn't worth what they said it was. Very, very clearly understandable. One thing I'm interested to find out is the original note. There's many court cases that say without the original notes, and I'll go to those court cases here after I explain this. Without the original note, not an original copy, not a copy, not someone standing up there and say, yes, I seen it. Without the original note being brought forth in an action, whether it be judicial or non-judicial, the alleged holder of the note has no rights because the original hasn't been brought forth. And that's clearly established for two reasons. One of those reasons is so that it can be proven to the court that the note was actually duly negotiated. What does duly negotiated mean? Duly negotiated means transferred. According to the Securities and Exchange Act, that is. That's not my words. That's the Securities Act. Says that negotiated means a sale or exchange or transfer or delivery. So when you are the only one that can sign this and give it to the bank, it's been transferred. Regardless of what was exchanged for it, it was still transferred. So it's been a transfer. And that's what they call duly negotiated. The second reason is more important to me than anything else, because the second reason is to assure that if I'm accused by a bank under one of these alleged notes and they don't bring forth the note, the original note, not a copy, the original note, if a judge honors in favor of the bank, the note may resurface later and I might twice be charged for the same thing, which is a violation of constitutional law for being charged twice for the same occurrence. It's absolutely a judicial precedent that that note be there so that the court knows that it was duly negotiated and that you cannot be charged later if the original note does surface. And that makes absolute common sense. And I will now bring you to some court cases that actually talk about that, because it's not just one or two that I've picked out of the limelight. It's several. Well, that's just one. Let me go to cases, banknotes many. Now here, a promise to pay cannot, by argument, however ingenious, be made the equivalent of actual payment. This promise, they do call it a promissory note, right? It's a promise. A promise to pay, which is this, cannot be made the equivalent of actual payment. That right there again, going back to where's the debt, again, cannot be this. They just proved it one more time. I do, however, believe that that's authorization to make the money. I don't think it is the money, but it's the authorization to make it. McKay versus Capital Resource Company, where Pelley apparently never possessed appellant's original note as provided in Arkansas Code annotated. You notice how the court always uses the annotated versions when they give their opinions? But was required, even if it had, to have proven all three factors specified in that section and did not do so, appellee could not enforce the original note's terms by the use of a copy. Cannot use a copy. It has to be the original. There's got to be a way. I wonder if I can do a page down. Mortgage Securities, Inc. versus Hartley Lord, July 2003. That's a real old case. Mortgagee by assignment brought foreclosure action. The Circuit Court, 15th Judicial Circuit, Palm Beach, Florida, John Wessel, J.J., entered summary judgment for mortgagor, which is a customer. Mortgagee appealed. The District Court of Appeals, Stone J., held that the mortgagee could not maintain cause of action to enforce missing promissory note or foreclosed mortgage in absence of proof that mortgagee, banker, or assigner ever had possession of it. In other words, that case kind of goes both ways. It says that we need to have proof that they never had it, but in the same sense, they need to prove it. And the reason that he lost here on this one is because he appealed it. And that's the burden of proof clause that comes in. If the bank is coming after you, they have the burden of proof. If you're appealing it, you now have the burden of proof. So hopefully that makes that sensible. And that it jumps. Lorraine Tillman, Virginia Savings Smith. The purpose of this section is well expressed in commentator Carl Edhart as follows. The drafters of the code excluded from the general rule of admissibility of duplicates these documents because the possessor of the document is the owner of the obligation. The possessor, if I'm a bank and I'm the possessor of this, I possess the document, I'm the owner of the obligation that they represent and the party who may bring a cause of action based on the document. Therefore, a person who possesses the duplicate may not possess the cause of action. Just because you have a duplicate does not give you rights to go into court. Mason versus Rubin, 1999. That was a 1985 case, by the way. Establishing a lost negotiable instrument is governed by a different statute. The latter statute contains more stringent requirement than the former. And the trial court correctly concluded that the husband did not satisfy that section. I can't even pronounce that word. This is a 1989 case in the 3rd District, Florida. Plaintiff failed to produce for admissions into evidence the original copy of a negotiable promissory note, promissory instrument, as expressly required. For this reason, the final judgment of the foreclosure is vacated with directions for the trial court receive the original promissory note in evidence. In other words, they're saying that they need the original promissory note, otherwise they cannot foreclose. SMS Financial, where the complaining party cannot prove the existence of the note, then there is no note. I don't even need to read the rest of that one. That one's real clear. Florida statutes is misplaced. The purpose of the subsection is to require production of the original note where there is an action on a negotiable